Welcome to the MOOC lecture on appointment of judges and the collegium system. India is a federal country, and a federal constitution's one of the features is independent and impartial judiciary. India has strived for an independent judiciary, but whether it has maintained independent judiciary or not is a million-dollar question. The independence and impartiality of Indian judiciary is proportionately connected to the procedure of appointment of judges to the higher judicial service, that is the High Court and the Supreme Court of India. India has one Supreme Court and 25 High Courts within its territories. Let us examine the constitutional provisions for the appointment of judges of the Supreme Court and the High Court. Article 124, Clause 2 lays down, every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such judges of the Supreme Court and the High Courts in the states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. Provided that, in case of the appointment of a judge other than the Chief Justice of India shall always be consulted. Article 217, Clause 1 states, every judge of a High Court shall be appointed by the President by warrant under his hand and seal after consultation with the Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than the Chief Justice of the High Court, and shall hold office in the case of an additional or acting judge as provided in Article 224 and in any other case until he attains the age of 62 years. Now, let us try and trace the development of the so-called collegium system in India. India is the only country in the world where judges appoint the judges. It is a system of appointment and transfer of judges that has evolved through judgments of the Supreme Court and not by an act of Parliament or by a provision of the Constitution. The word collegium is nowhere mentioned in the Constitution. It has come into force as per judicial pronouncements. The origin of the collegium system may be traced by the recommendation of the Bar Council of India made on October 17, 1981 during a national seminar of the lawyers at Ahmedabad. It was recommended that there should be a collegium for the appointment of Supreme Court judges. Recommendations for the appointment of Supreme Court judges should be sent to the President by a committee consisting of the following members: the Chief Justice of India, 5 senior judges of the Supreme Court, 2 representatives who would be representing the Bar Council of India and the Supreme Court Bar Association. The recommendation of such a collegium system should be binding on the President, though he can suggest reconsideration on certain grounds. This was the first idea of collegium system suggested in 1981. Now let us look at, in the hindsight, on certain historical developments of the collegium system. On 24th of April 1973, the landmark judgment of Keshavananda Bharati versus State of Kerala was delivered, and Honorable Chief Justice Sikri retired, and the question of appointment of the next Chief Justice of India came up for consideration. Till 24th April 1973, the practice was to elevate the senior-most Supreme Court judge as the CJI, seniority in terms of experience as a judge. On 25/4/1973, breaking this convention, Mr. Justice A.N. Roy was elevated as the Chief Justice on 25/4/1973, superseding 3 senior-most Supreme Court judges, namely Justice Grover, Justice Shellath, and Justice Hegde. In protest, the 3 senior judges resigned, and they boycotted the swearing-in ceremony of the new Chief Justice of India. A writ of quo warranto was also filed against Mr. Justice A.N. Ray at Delhi High Court, the case being P.L. Lakhanpal versus A.N. Ray. Another such instance could be referred here, where Mr. Justice Beg was elevated as Chief Justice of India, superseding Mr. Justice H.R. Khanna after the judgment of ADM Jabalpur versus Shukla. In Sankal Chand Himatlal Seth versus Union of India, the President transferred Mr. Justice Sankal Chand Seth from Gujarat High Court to Andhra High Court without his consent. He complied with the presidential order, assumed his office, yet challenged the order being violative of Article 222, Clause 1 and Article 217, as neither his consent was obtained under Article 221, nor did the executive hold an effective consultation with the Chief Justice of India. But the presidential order was upheld, and the bench constituted Justice Chandrachud, Justice Bhagwati, Justice Krishna Iyer, Justice Untwala, Fazal Ali and Justice Syed Murtaza. Now comes the popular case of Judges Transfer Case number 1, SP Gupta versus Union of India. In the 7 judges bench verdict, while elaborating on the meaning of the word consultation, Justice Bhagwati endorsed the views of Justice Krishna Iyer expressed in Union of India versus Sankal Chand Himmatlal Seth that consultation is different from consentaneity. They may discuss but may disagree. They confer but may not concur. The majority view abdicated its power by ruling that constitutional functionaries had merely a consultative role and the power of appointment of judges is solely and exclusively vested in the central government. In case of difference of opinion between the President and the CJI, the President's opinion shall prevail. It declared that the primacy of the Chief Justice of India's recommendation on judicial appointments and transfers can be refused for cogent reasons. The ruling gave the executive primacy over the judiciary in judicial appointments for the next 12 years. So, in the Judges Transfer Case number 1, we find that CJI had the Chief President had the primacy, the executive had the primacy and not the Chief Justice's opinion. Now, let us examine the next steps towards evolution of the collegium system. However, Justice Bhagwati in the first judge's case expressed his dissatisfaction with the existing mode of appointment of judges in India, in which the authority to select judges has exclusively been based in a single individual, the President, whose choice may be incorrect or inadequate and may also sometimes be imperceptibly influenced by extraneous or irrelevant consideration. That was aired by Justice Bhagwati in the previous judgment. He considered it unwise to entrust power, particularly to make crucial and sensitive appointments such as judicial appointments to single individual, the President, without putting checks and controls on the exercise of such power. Accordingly, he suggested that a Supreme Court, there must be a collegium to make recommendation to the President in regard to appointment of a Supreme Court or High Court judge. The recommending authority should be broad-based and there should be consultation with wider interests. The collegium is composed of persons who are expected to have knowledge of the persons who may be fit for appointment on the bench and of qualities required for appointment, and his last requirement is absolutely essential. The Law Commission in 1987 in its 121st report suggested for the formulation of a judicial commission, that is a group of people who can recommend the President, and the appointments will be based on those recommendations. The Parliament on this note introduced 67th Amendment Bill in the year 1990. However, with the dissolution of the 9th Lok Sabha, the bill also lapsed before the transformation into law. Then comes the Judges Transfer Case number 2, Supreme Court Advocates on Record Association and Union of India. In this 9 judges bench decision, the Supreme Court by 7:2 majority overruled SP Gupta, the first Judges Transfer case, and observed that in the matter of appointment of the judges of the Supreme Court and High Courts, Chief Justice of India's opinion shall have primacy. CJI will take into account views of 2 senior-most judges. This would ensure that the opinion of the Chief Justice was not merely his individual opinion, but an opinion formed collectively by a body of men at the apex level in the judiciary. The great weight should be given to the opinion of the Chief Justice and senior-most judges of the Supreme Court. The primacy should be given to CJI in matters of appointment of judges of the Supreme Court. Further, it was observed that holding that consultation really meant concurrence. So it was a 180-degree turn from the earlier decision. In the earlier decision, it was said consultation doesn't mean concurrence and President's opinion will have primacy. But in this case, it was just the opposite. The Supreme Court declared consultation means concurrence. This is how, for the first time, the seeds of collegium system were sown in this case, which got finalized in the next case. The next case, which is known as the Judges Transfer Case number 3, in re-presidential reference, AIR 1999, Supreme Court 1. This 9-judge bench case unanimously formulated the collegium system. Appointment process will be initiated by the CJI. Recommendation will be sent to the President and the President will give appointment. The CJI sending recommendation should consult other judges as per the following table. For appointment of Chief Justice of India, senior most Supreme Court judge should be elevated as Supreme Court judge, Chief Justice of India. Other Supreme Court judges, the Chief Justice of India should consult 4 senior most Supreme Court judges. If 2 of them give adverse opinion, CJI should not send the recommendation. For appointment of High Court judges, Chief Justice of India should consult 2 senior most Supreme Court judges. Transfer of High Court judges, CJI should consult 4 senior most Supreme Court judges, 2 High Court Chief Justices, that is from and to. From the High Court where they are getting transferred and to the High Court where they are getting transferred. Now, if we analyze the decision of the Supreme Court case number 3 on judges transfer, the opinion of the CJI having primacy in consultative process and reflecting the opinion of the judiciary has been formed on the basis of consultation with the collegium comprising of the Chief Justice of India and 4 senior most judges of the Supreme Court. The judge who is to succeed the CJI should also be included if he is not one of the 4 senior most judges. Their views should be obtained in writing. Views of the senior most judges of the Supreme Court who hail from the High Courts, where the persons to be recommended are functioning as judges, if not the part of the collegium, must be obtained in writing. The recommendation of the collegium, along with the views of the members and that of the senior most judges of the Supreme Court who hail from the High Courts, where the persons to be recommended are functioning as judges, should be conveyed by the Chief Justice of India to the Government of India. The substance of the views of the others consulted by the Chief Justice of India or on his behalf, particularly those of non-judges, should be stated in the memorandum and be conveyed to the Government of India. Normally, the collegium system should make its recommendations on the basis of consensus, but in case of difference of opinion, no one would be appointed if the Chief Justice of India dissents. If 2 or more members of the collegium dissent, CJI should not persist with the recommendation. In case of non-appointment of persons recommended, the materials and informations conveyed by the Government of India must be placed before the original collegium or the reconstituted one. If so, to consider whether the recommendation should be withdrawn or reiterated. It is only if it unanimously reiterated that the appointment must be made. The Chief Justice of India may, in his discretion, bring to the knowledge of the person recommended the reasons disclosed by the Government of India for his non-appointment and ask for his response thereto, which, if made, be considered by the collegium before withdrawing or reiterating the recommendations. Merit should be the predominant consideration, though interseniority among the judges in their high courts and their combined seniority on all India basis should be given weight. Cogent and good reasons should be recorded for recommending a person of outstanding merit regardless of his lower seniority. For recommending one of the several persons of more or less equal degree of merit, the factor of high courts not represented on the Supreme Court may be considered. The judges passed over can be reconsidered unless for strong reasons it is recorded that he be never appointed. The recommendations made the Chief Justice of India without complying with the norms and requirements are not binding on the Government of India. Now, let us examine whether the collegium system is functioning effectively or not down the years. As Justice Ruma Pal of the Supreme Court, former judge, describes it as the best kept secret within the 4 walls of the body, and it makes it immune from executive influence. If the appointment and the transfer of judges is immune from executive and the legislature, obviously, theoretically, it becomes really independent. But how far has it been effective, we'll shortly examine. So, the functioning of the collegium down the years, how far is it effective? As some critics, some jurists express their opinion that it somewhere disappoints. The collegium system as it is functioning is not as effective as it was thought to be. This system does not provide any guidelines in selecting the candidate for the judge position of the Supreme Court, because of which it leads to wide scope for nepotism and favoritism. The collegium system does not have any criteria for testing the candidate, as well as they don't investigate any background of the candidate, and they are not accountable to any administrative body that may lead to wrong choice of the candidate while overlooking the right candidate. In other words, there is absolutely no accountability and no transparency and no basis on which a candidate is selected. Already there are 69,000 cases pending in the Supreme Court and almost 59 lakhs in the High Court across India. They are having limited time to devote for selecting judges because a lot of judicial work is pending. The principle of check and balance is violated in this system. How? There are three organs: executive, legislature and judiciary. And the mechanism of the constitution is so nicely balanced that there are checks and balances amongst these three organs. But while appointment of judges by the collegium, the judiciary is made immensely powerful, and there is no check and balance by the other two organs on the judiciary in the matter of appointment of judges to the highest judiciary, that is the Supreme Court and the High Courts. This system leads to non-transparency of the judicial system, which is very harmful for the regulation of law and order in the country. This is the view expressed by many jurists. Now, after 10 years of the establishment of the collegium system in 2003, the government of the National Democratic Alliance made an attempt to replace this collegium system with National Judicial Commission consisting of 3 ex officio judicial members and 2 executive appointees. Through the presentation of the Constitution, 98th Amendment Bill before the Lok Sabha. In order to ensure greater transparency and the role of the executive in the appointment of judges of the Supreme Court and the 21 High Courts, the Union Law Ministry drafted a constitutional amendment bill to replace the existing collegium system with a 2-tier National Judicial Commission, one for the appointment of judges of the Supreme Court and another for the appointment of judges of the High Courts. But in July 2012, the Law Ministry introduced changes in the bill to replace the proposed 2-tier National Judicial Commission system into a single tier. At the same time, a new provision has been incorporated into the bill providing for the attendance of the relevant chief ministers in the meeting of the commission if his input is considered necessary for the appointment of High Court judges. So, 99th Constitutional Amendment, at last the government, inspired from UK, brought the 99th Amendment in 2014 and the National Judicial Appointment Commission Act 2014 was passed. The NJAC was comprised of the Chief Justice of India as ex officio chairperson, 2 senior-most Supreme Court judges ex officio members, the Union Minister of Law and Justice ex officio member, 2 eminent persons from civil society to be nominated by a committee consisting of the Chief Justice of India, Prime Minister of India and the Leader of Opposition in the Lok Sabha, one of the eminent persons to be nominated from SC, ST, OBC, minorities or women. Now, in Supreme Court Advocate on Record Association versus Union of India, which is popularly called the 4th Judges Transfer case, Supreme Court struck down the NJC Act by 4:1 majority. Justice Keher, Justice Lokur, Justice Kurian Joseph, Justice A.K. Goel, and the minority opinion was delivered by Justice Chamaleshwar. The Supreme Court held, separation of power is a part of the basic structure of the Constitution. Appointment of judges is a core function or power vested in the judiciary and can't be impugned upon either by the executive or by the legislature. Now we had the Rule of Law Convention in 2018 on collegium. The Bar Association of India held the Rule of Law Convention in 2018 on judicial reforms between 9 and 11 February 2018, saw a participation of nearly 200 delegates from 21 states representing bar councils and high court and district bar associations. The main proposition was that whether collegium system of appointments should function as it was rejected completely and unanimously. The proposition as to whether collegium systems should be abolished and executives should be allowed to play a role in selection of judges was also rejected, only 14 votes in favor. Lastly, whether the collegium system of appointment be continued with significant reforms and changes to bring in transparency and evolving mechanisms to ensure the best talent is appointed to court was carried. So, from the above discussion, what are the takeaways? The judicial appointments should not get delayed or postponed due to non-finalization of the judges. The filling of judicial vacancies is the duty of every organ of state. It was noted that checking of background while appointing is flawed, and such ground checks are purposely leaked in public domain to create doubts about integrity of candidates. Also, the machinery to carry out background checks is not misused, must be assured. A well-resourced independent secretariat for judicial appointments and a database of eligible candidates be created so that vacancies are known in advance for faster judicial remedy. Both the judiciary and executive should work together in a spirit of collaboration to ensure speedy filling up of vacancies by keeping supreme the national and public interest in mind. Now we have the National Judicial Commission Bill 2022. The National Judicial Commission Bill 2022 was introduced after the majority of voice votes were in its favor. The bill aims to regulate the procedure to be followed by the National Judicial Commission for recommending people for appointment as the Chief Justice of India and other judges of the Supreme Court and Chief Justices of other high courts. It also aims to regulate their transfer and to lay down judicial standards, provide for accountability of the judges, and establish credible and expedient mechanism for investigating into individual complaints for misbehavior or incapacity of a judge of the apex court or of a high court, and to regulate the procedure for such investigation. It also proposes for the presentation of an address by Parliament to the President in relation to proceedings for removal of a judge and for matters connected therewith or incidental thereto. While separation of power can't be denied, at the same time, the words of Justice Verma, who was one of the ardent supporters of the collegium system, is also noteworthy. He said, judicial appointments have become judicial disappointments, and that working of the judgment now for some time is raising serious questions which cannot be called unreasonable. Therefore, some kind of rethinking is necessary. On another note, the Constituent Assembly figured for the independence and impartial judiciary regardless of anything. So what is the way forward? According to the Constitution, we need an impartial and independent judiciary which is immune from executive interference or legislative interference. On the other hand, the working of the collegium down the ages have raised questions regarding impartiality in the appointment, nepotism and favoritism. The courts, the jurists and the minority opinions in many cases have clearly stated that there are lacuna in the judicial appointments in the collegium system. The main lacuna being non-transparency, opacity, no standard laid down for elevation of a person into as a Supreme Court or a High Court judge. No particular procedure is free from defect. Today there is collegium. If tomorrow the government get the primacy, the custodian of the Indian Constitution may go under the whims and caprices of the government. That is also true. To ensure the effectiveness of this mechanism, the Commission should be representative in nature, comprising members of the executive, legislature, judiciary, legal profession, including academicians. It should be ensured that the Commission uses a system which is transparent and open to the public scrutiny, and maintain public confidence. Additionally, the Apex Court should open itself for constructive criticism so that it can widen its further growth. The model of South Africa, Canada, and other countries' approach should be looked into. In this context, the immortal words of former Chief Justice of Australia, Sir Harry Gibbs, are worth quoting. Judicial commissions, advisory committees, and procedures for consultation with the Chief Justice will be useless unless there exists among the politicians of all parties a realization that the interest of the community requires that neither political nor personal patronage nor a desire to placate any section of a society should play any part in making judicial appointments. Thank you.